Good afternoon, everyone, and welcome back to this week's episode of the Digital Law News, produced by Anson Evaluate. I'm Amelia Davies, an apprentice solicitor at Digital Law UK. I'm joined by my colleague, Peter Wright, and we're just going to run through some of the news stories that have been coming up this week. I'll pass over to Peter to introduce himself, and then we will get started.
Thank you, Amelia. My name is Peter. I'm a solicitor and the Managing Director at Digital Law, and we've got a few stories to bring you, in particular some quite interesting information with regards to the ICO and the National Cybersecurity Centre. So I'll pass back to Amelia to take us through.
Thanks, Peter. So today we are getting started with Russia. So Russia are fining Google over the materials that have been shown in relation to the war in Ukraine. And so Russia has hit Google with a 21.1 billion ruble, which is approximately £301 million fine, for failing to restrict access to prohibited materials about the war in Ukraine and other content. And so this is kind of included in the fake reports that the Russian military have posted urging people to protest. And I mean, when I kind of gave Peter the lowdown on this story earlier, it didn't come as a surprise, did it, Peter?
No, there have been quite aggressive actions by the Russian government to some of the large US tech firms. So Meta, which of course includes WhatsApp, has already been banned in Russia for spreading what they call sort of fake news and misinformation, or as I think we'd probably call it, fact. And this is a similar attempt here by Russia to, in short, extort money from Google for spreading material about the war on Ukraine that the Russian government would rather they didn't. It's an interesting aspect here in that already the sort of the local Google subsidiary has been in the process of, it's bankrupt, having had its local bank account seized. And already we've had, I say, these very aggressive actions taken by the Russian government. I mean, it's an interesting question. Will Google even bother to pay the fine at this point? And if it could be that it just turns around and looks at Russia as a market that's now gone, or certainly as a market that's gone under the current regime in Russia, cuts its losses and says, thank you very much, goodbye. Let's face it, when you're looking at having lost 7.2 billion rubles and then 2.21 billion potential fine, the cost of doing business is likely greater than the actual profitability of continuing to operate there. So, I mean, it's also interesting to think, I wonder if actually paying that fine, would that be breaking the sanctions? And the answer is probably not, because of course you've got, even European governments are continuing to pay Russia vast sums of money for fuel and oil. So you can still have financial transactions in Russia, and you can imagine that paying a regulatory fine would be permitted. But in this instance, arguably when the rule of law is collapsing, if it hadn't already done so in Russia, then indeed, why would you, as I say, bother to pay the fine at this point? Just a sad day for Russia and for those who did previously rely on Google's services. I have heard interviews with Russian nationals who were already very upset when things like their iPhones and Google wallets and Apple Pay stopped working almost overnight after the Russian invasion in February. And so suddenly when you can't move your money around, you can't pay in the way that you otherwise did, and you can't use the tools that you'd come to rely on, that actually has a significant impact. And if you'd already lost Apple, you might have been relying on the Google suite of tools. So everything from Gmail to Google Maps to GPS tracking and all of the things that Google does and does well. You'd potentially be looking at the loss of that. So you can imagine that those who had been using those tools, which will include not just individuals, but businesses operating in Russia, then they're going to be impacted by the potential withdrawal of these services in particular.
Thanks, Peter. So moving on to our next story, and this is one, in fact, you mentioned when you're introducing yourself. So this is looking at the rise of ransomware payments. So requests from the National Cybersecurity Centre and the ICO, the Information Commissioner's Office, follows rising ransomware payments being made. So the organisations are asking the Law Society to remind solicitors of their advice on ransomware and emphasise that payments of ransomware will not keep the data safe or be viewed as by the ICO as a mitigation if there is a breach. And this is really important for us specifically when we're advising our clients. We're always saying, just do not pay the ransom, because actually in a few cases, more increasingly actually, you will pay the ransom and then you will have your information double encrypted, and then your ransom is literally done nothing. And therefore, it's very important for us when we are advising our clients to make sure that they aren't therefore feeding the beast. So I'll pass over to Peter to continue.
Thanks, Amelia. You've just covered in a nutshell what the advice should be, and it is incredibly disheartening to hear from the ICO and the NCSC that it appears to be lawyers that are running around telling their clients not that they should just pay cybersecurity, cyber ransom fees to access data. It is, I mean, it's quite pithy here what the ICO has written. In recent months, literally, this is word for word. In recent months, we have seen an increase in the number of ransomware attacks and ransom amounts being paid, and we are aware that legal advisors are often retained to advise clients who have fallen victim to ransomware on how to respond and whether to pay. It has been suggested to us that a belief persists that payment of a ransom may protect the stolen data and or result in a lower penalty by the ICO should it undertake an investigation. We would like to be clear that this is not the case. That is damning, because it's saying, do not listen to the professional advice you may have paid quite a penny for. It's saying that do not feed the beast, don't pay the ransom, don't think that will mean you can access the data again, and don't do it thinking you'll get an easy ride from the Information Commissioner's Office. And it begs the question why lawyers have been stating this as advice. I mean, they're certainly not looking at any precedent. They're certainly not looking at any good practice from any regulator, any representative body. This goes against even the formal guidance written by the Law Society itself on things like what to do in the event that you are subject to a cyber attack. It goes against all the guidance in the Law Society's cybersecurity toolkit. I should know, I wrote the thing. And I just cannot quite get my head around, therefore, why in the face of all that. And don't forget, as I say, this is professional advisors who are being paid by the clients to give good advice, and they're turning around and saying this. On as I say, the basis upon which they're saying that beats me. Where are they getting it from? No one's saying that's a good idea, apart from lawyers who appear to have got it into their head from somewhere that it is, and it is categorically not, for the avoidance of doubt. And I mean, the Law Society here has had to take this step to say, oh yes, well, we'll remind our members to make sure they shouldn't be doing that. But given that they did, clearly the legal profession wasn't listening to the Law Society anyway, so whether this will make any difference, I don't know, because they've certainly not been listening to the guidance that the Law Society put out anyway, so why should they listen this time? But you can, the way that this guidance is put together, you can, the words are dripping with the anger and annoyance of the NCSC and the ICO that they're having to make this statement and having to waste their time making what should be blindingly obvious guidance clear to the members of the legal profession. It's as a lawyer, as a solicitor, I'm embarrassed they've had to write that. It is shameful.
Thanks, Peter. So with that in mind, moving on.
Indeed, come back next week. I'll tell you what I really think. So yeah, there you go. It's the mind boggles. It really does, frankly.
Thanks, Peter. So moving on and keeping with the theme of the National Cybersecurity Centre. So spy chiefs have intervened in the route over end-to-end encryption, stating that technology giants can scan online messages and pick up child abuse material without sacrificing privacy rights. And so this story on the surface goes back to, I think, a story we covered a few weeks ago, Peter, where it was looking at digital fingerprints of images containing child abuse. And so this would work, as one would think, as a fingerprint. Each image is kind of given a specific tag, which an algorithm can then recognize and then see where and who it is distributed to. Whereas kind of the thing of end-to-end encryption is you might not be able to do this in the same way. However, this is what the security chiefs are saying. So I will pass over to Peter to continue with this.
Thanks, Amelia. This is an interesting story because in effect, there's several things wrapped up in it. First of all, there's the fact that large platforms like Meta and others are relying on AI and machine learning to help them when it comes to trying to identify if there is harmful content on their platforms. And the specialists here are saying that might not be necessarily the most reliable way of doing this, and that you can't necessarily just rely on the AI and the machine learning. It could be that you can use it to whittle down what are potentially problematic images, but it could be, or content, but it could be that then after it's been sifted, it then needs a physical inspection. And if that means you've got to have more content moderators to do that, well, when we're talking here about platforms that are making tens of billions of dollars in profit every year, that's something they can probably afford if they really, really had to, even if it would affect the bottom line and the dividend you can pay out and all of those nonetheless important metrics. But also it's going to the heart of the fact that many of these platforms, so for example, WhatsApp, which is owned by Meta, has end-to-end encryption, but it's making it quite clear that even if it does have that encryption, because it might be encrypted on the handset, that it's also going to be present not just on a handset, but also on a server somewhere. This reinforces the point that I am making until I'm blue in the face, that WhatsApp is not suitable for business purposes because they're having to scan it for content like this. Because it proliferates so heavily. So once again, you therefore should not have commercial, confidential, business sensitive content on WhatsApp, simply because those platforms are subject to surveillance for these sorts of things, despite the fact it says, oh, this platform is end-to-end encrypted. And it also gets across the problem in the online safety bill, which is trying to say, look, I think that's very worthy aims, the online safety bill. It is trying to deal with a growing problem that is undoubtedly a menace to society, and it's trying to offer better child protection. It is the way it tries to do it that is a problem. We've already heard of some of the issues that could lead to freedom of speech problems with the online safety bill and the online harms. But in this instance, platforms are saying that we aren't sure that this is necessarily something that we can do. And instead here we've got organisations like the National Society for the Protection of Cruelty to Children, as well as NCSC and GCHQ, saying that it is possible to find and identify this kind of abusive content without breaking encryption. So this comes down, as you say, Amelia, to those sort of storage of fingerprints, so you can identify this stuff if it's on a user's device or on a server. And it's now going to be a matter of saying that the platforms might not like it, but regulators like those in the UK and those in other countries are starting to say, look, it is no longer enough for the platforms to turn around, bury their head in the sand and say, we're not going to do anything about this. And they keep hiding behind it saying, oh, well, we need to preserve human rights and freedom of speech. And it's like, well, that's all well and good, but what are you going to do about these images and this content? And really, it's got to be a matter of, rather than just burying your head in the sand saying, no, we're not going to do something. It's like, well, if you don't want to introduce this type of surveillance, what are you going to do? Rather than saying, we are not going to do anything. That is currently the sort of the place between the rock and the hard place where these firms find themselves. And I think it is becoming a burden on them that they have to discharge to turn around and say, well, we aren't going to do what you're asking, but we're going to do something else, perhaps to be able to ensure that this sort of content is not proliferating in the volume that it is, because it is getting to the point that it is, even though these platforms are incredibly useful and helpful, and we wouldn't have been able to probably get through the pandemic with the level of whereby these sort of apps were being relied on for communication while people were having to isolate, it does beg the question, what is the actual social value of them if they are being used to to encourage and facilitate the sort of harm and abuse that we are finding is the case.
Thanks, Peter. Sticking with big tech giants here, Apple has announced a new security feature to protect high-risk users from spyware and cyber attacks. So lockdown mode will be available in the autumn with the next operating system across all of the company's iPhones, iPads, and MacBooks. The setting blocks certain functions and prevents unknown users from calling. This comes after Apple devices owned by activists, politicians, and journalists were infected with spyware. So Apple is currently suing Israeli spyware firm NSO Group, which they've accused of targeting victims in 150 different countries with its powerful Pegasus software. So I believe this is something we may have covered before, and I will pass over to Peter to go through it in more detail.
Yeah, this is interesting because this sort of technology is often used by security services and law enforcement. So, for example, they would use it to be able to, if they get hold of a message, or if they get hold of a device, or if they are targeting a individual that is a suspect, you'd be able to go through, extract all of the SMS text messages on a device. You'd be able to get hold of any photographs, any emails from accounts that are synced. Be able to record phone calls, activate microphones, cameras. This is sort of, when it says spyware, we're talking about full command and control of a mobile device. And in this instance, this company is an Israeli spyware firm, NSO, and they're saying, look, our tools are made so we can go after the bad guys and we can target terrorists and criminals, and that we only supply this stuff to military, to law enforcement and intelligence agencies, and then we only give that to the countries where there's things like the rule of law, and that we think this stuff is going to be used safely and responsibly. But in this instance, Apple is saying, look, this stuff has been sold far too widely, so you have it being used by governments and government agencies in countries where it might not be being used for what it is intended for, and instead could be used to suppress opposition to the government. It could be used to clamp down on freedom of speech, freedom of thought, dissent, and that's what they're really concerned about here. And Apple's faced criticism for not really protecting its users in the past. So this is a very visible way of being able to turn around and saying, we are taking on a company here that has allowed for the proliferation of spyware, which has made our devices a lot less secure than they otherwise would be. So hence they're suing them, and hence they're also issuing this lockdown mode, which in theory would then mean that spyware would be less effective. Don't forget, though, the minute that they go and give out something like this lockdown mode, that will be produced, and then someone else will come up with a form of spyware that will circumvent the controls in lockdown mode. So it's just an arms race at this point. It's not a total solution to the problem.
Thanks, Peter. And our next story again is looking at tech company failures. And so essentially, tech has grown far too quickly in the last few years, with Uber and Airbnb kind of coming out of the woodwork really quickly. And you will have seen the rise of Uber and how popular Airbnb have become. However, the government now plans to give regional mayors the power to curb Airbnb and protect the hotel industry, and the online safety bill is proposing an era of censorship in social media giants. And so we see that tech companies are being a lot more restricted now than potentially they were when they started. And so I will pass over to Peter to kind of go through this in more detail and what it could mean as we're going towards the future.
Yes, this is an interesting piece that sort of looks at the growth of platforms like Uber, Airbnb that had massive impacts on their market. So if we think about how Uber has been in the cities where it's operated, it has radically changed the market for taxis, both certainly for pre-booked taxis, but also through the app, it's kind of cut the feet out from underneath the traditional black cab operators in London, perhaps, and as it's also done in other cities, because suddenly you think, well, I can go on Uber and it's cheaper. And of course, the reason why Uber was cheaper was because billions of dollars of venture capital money was being hoovered up by these apps to allow the service to be offered more cheaply. And since the pandemic in particular, it's become clear that Uber has shoved its fares up to actually something closer to what they should have been charging in the first place, having spent the last sort of 5 years forcing a lot of its competitors out of business. You know, if you're in a town or city where Uber operates and other ride-hailing apps, you will have noticed that the traditional taxi firms very often have simply folded, merged, and gone out of business because they simply couldn't compete with the cheaper fares that Uber was offering. And the point here is that similar things happen with Airbnb, where it's meant that a lot of hotels, particularly the smaller ones, couldn't compete with the rates that Airbnb was offering. You've got security implications where suddenly it's turned out that people have been hosting parties in Airbnb lets, and security issues there, as well as with Uber, the fact that sometimes you've had people who shouldn't really honestly have been operating taxis have been doing so, and there have been numerous criminal cases that have flowed from that. But then this article tries to lift the veil on some of the dark dealing and lobbying that was taking place, looking at a lot of Uber's lobbying techniques. So, for example, things like campaign donations, nice consultancy contracts that were given out, sweetheart deals to allow Uber and apps to get into new markets. Even, and this is quite a damning thing, Uber apparently had a kill switch incorporated so it could hide certain data whenever regulators or the police threatened to seize it, to say, oh, it wasn't actually there. And in that way, you could potentially also, as well as doing that, you could route some of the profits, some of the money through tax havens, so it wasn't immediately apparent to governments and regulators. You know, if you aren't seeing clearly what the turnover and profit is, you can't necessarily gauge how widely used those apps might actually be. So the intelligence and the data points available to government and regulators to keep an eye on Uber, Airbnb, etc., was becoming problematic. In here, I should say here that this is all very much focused on Uber, all of the comments that are in this article. But clearly, as Uber then became more prevalent, you've then got the knock-on impact on labour laws, the fact that Uber drivers weren't classed as employees initially, until there ended up being litigation to change that. And certainly it looks as though this technology was very, very disruptive. It changed things. But there have been problems then with them getting into markets like in France, like in London, where occasionally the regulators have tried to do something, tried to threaten bans, but then ultimately have let Uber in, and they've then ravaged those markets that they've had the access to. So certainly the sort of tales here of very robust, muscular lobbying do not make governments and regulators look particularly virtuous, shall we say, in what's happened. But I can certainly recommend taking a look at this article. It is on the Spectator website. The title of the article is "The Uber Scandal Highlighting Big Tech Firms' Big Failure," and certainly food for thought there.
Thanks, Peter. And so moving on to a slightly different story. So typically on these podcasts, we focus on tech. However, as a small insight and as to kind of us as solicitors and the rules and regulations we have to follow, this story takes a look at this. So the SRA, the Solicitor Regulation Authority, alleged that by deliberately failing to pay rail fares worth approximately £650 for journeys undertaken over a 3-month period, a solicitor breached either or both Principle 2 and Principle 6 of the SRA principles. So essentially that's looking at integrity and honesty, and these are key principles that being a solicitor is kind of revolved around. And actually, although surface level you think, right, these principles only apply inside the office, the long and short of it is they really don't. So I will pass over to Peter to continue with this.
Yes, a lot of people don't realise this, that the whole point is that as a solicitor, you are an officer of the court, and you therefore have these professional obligations to act with integrity and honesty. And that just doesn't apply to when you're sat behind your desk in the office. It applies in everything you do. So it's a well-known fact that if you are ever convicted of a crime of dishonesty, you would be struck off as a solicitor. What this case demonstrates is that that will extend, in this instance, to willful fare dodging. In this instance, it was a young lawyer, newly qualified, who admitted not paying rail fares and that they didn't really have a good reason for not paying them. This was part of their daily commute. In respect of fares for that, we are talking about hundreds of pounds worth of fares that were not paid on several occasions, and it looks as though it is possible, for example, if the solicitor turned around and said, well, it was hardship and I had to go to work to having just qualified to pay off my debts, and I was so heavily in debt that I couldn't afford to commute, you know, the tribunal might have listened to that. But in this instance, it's saying, well, no, I did have the money to pay it, just didn't want to pay it. And that's a different matter. And that's where the element of clear dishonesty with no mitigation in any way, shape or form. And in this instance, it's quite striking that, you know, this person has had to end up being dismissed by their firm. They expressed remorse for their actions and ordinarily would have done the right thing in both their professional and their private life. But in this instance, it's the fact that they failed to pay for 82% of their journeys to and from work. And you are supposed to do that. And we're looking here at not just one or two. You know, it's not like someone's failed to pay for a tube journey or something. We're looking at over £600 worth of rail fares daily that were not being paid. That's not £600 a day. The whole lot adds up to £600, but it was the money from the daily commute that simply wasn't being paid. And this the other thing is they only stopped when they were caught by a fare inspector, who stopped and said, why haven't you got a valid ticket? And therefore, it's that sort of thing over the whole of the reputation, her reputation, firm's reputation, reputation of the legal profession, which the regulator always takes a rather heavy view on. And in this instance, as I say, there was no element of mitigation. But this comes down to the fact that, you know, if you are a lawyer, the integrity is a crucial bit, but also the behaving in a way that maintains trust, the trust that public places in you and in the provision of legal services. And, you know, it's a problem if you've got someone who, in this instance, is willfully going around not paying rail fares. I once had someone who got in touch with me and said, you know, I was sat at a table in a restaurant and I could hear there's a table nearby full of young lawyers, and I know they were lawyers because they referred to the office where they worked, and they were referring to clients, and they were discussing work, and they were drunk, and they were shouting loudly, and they were being abusive to the staff in the restaurant. I actually ended up speaking to the managing partner of that firm, saying, you need to do something about this. And of course, then they couldn't find any evidence that it had taken place, apart from the fact that I was telling them, look, someone did report this, and you really should make sure it doesn't happen again. You know, that's the sort of thing that then would be a breach of Principle 6 in that instance. So it just kind of shows that, I'm afraid, lawyers, you have to think about your integrity. You have to think about what people will think about your behaviour at all times. Failure to do that could lead to you being struck off and paying costs, as happened in this instance.
Thanks, Peter. And moving on to our last story of today. I mean, I believe we have spoken about Elon Musk, Tesla and Bitcoin in various podcasts throughout this year. And well, as you might be surprised, this podcast isn't going to be any different. So Tesla has offloaded 75% of its Bitcoin, which is worth about $2 billion at the back end of 2021. It is backing away as the value of cryptocurrency has plunged, falling by more than 50% this year. And does this come as a real surprise, given the fact that cryptocurrency has dropped off so quickly? Probably not. However, this goes back to the fact that Elon had previously tweeted, and we all know how much he likes to tweet, that he was not going to be selling any shares. So I will pass over to Peter to continue with this.
Thanks. I think this is just an interesting story to show the difficulty in engaging in trading at the moment in very volatile cryptocurrency. It looks like, compared to the initial investment that was made about 1.5 billion, they've made a couple of 100 billion, lucky them. But when you put in 1.5 billion and you're able to then get out 2 billion, that is a bit of a result. However, clearly it will have been a bit of a roller coaster to get to that point, given that Bitcoin went up to $70,000 at one point before then collapsing to $25,000 in value. It remains a very, very volatile market. It also remains sometimes a very difficult market to get your money out of. And for anyone out there who is either considering investing in cryptocurrency, and maybe thinking, oh, the market's low, I'll put some money in. Just bear in mind that you want to make sure that if then you need to get your money out, you can do so. How long would it take? What controls would be in place? What would they be asking for? What hoops would you have to jump through before you could then get what money you've got left out from the investment that you might have put in? And as always, bear in mind with an investment like that, can you afford to lose it? I think is the key question you would need to bear in mind.
Thanks, Peter. I think it's important to mention here, this area is vastly unregulated, and so kind of like you were saying, when you're trading and looking at investing, it is really important to think about how you are going to be getting that money back out should you wish to, because there is no hard and fast rule.
Indeed, and a final word is for any law firms advising on or acting in transactions involving cryptocurrency. Always remember that you would need to put together a risk assessment, and that any other lenders involved might be hoping to rely on you as the law firm to be experts in this and to rely on your risk assessment. So I did hear of one transaction where the lawyers weren't sure about even where to begin with the risk assessment. They thought, I know, we'll use the bank's risk assessment. So they called up a well-known high street bank, and that well-known high street bank said, oh, we were hoping we could rely on yours because we don't have one. So always make sure you've got a decent risk assessment on there that will stand up to scrutiny. Ask yourself questions about the source of the funds. Where has the money come from? With cryptocurrency, of course, it's maybe backed up by a distributed ledger blockchain, but over and above that, can you actually verify what the actual source of the funds was? Can you prove the veracity of where that money has come from? Is there a clear trail that you can follow? If that cannot be proved or verified, you might be falling foul of anti-money laundering rules. So therefore, for law firms that are doing this, I'm not saying don't do it. I'm just saying you have to be incredibly careful to make sure that you are doing this in a manner that is protecting you and protecting the interests of your client. Regardless of which side of the transaction your client may be on. If in doubt, speak to the SRA. They will not tell you, no, you can't do it, but they will have some advice and guidance. They are particularly worried where it could be that the transaction is ultimately a source of funds coming from overseas. So that's where then that can be a red light, depending on the jurisdiction overseas where the money might be coming from. So these are all things that you'd need to bear in mind and take account of in a risk assessment very, very carefully. So I think that is something to bear in mind. And finally, just a word on it. We talked in this story about the sort of the up and down nature, the roller coaster of cryptocurrency this year, and it has taken a bit of a beating. And a lot of people saying, "Oh, well, clearly that's it now. Cryptocurrency is bust." And I don't think it is. I think the underlying technology makes a lot of sense, and I think it could well be. If it isn't the future, I think it certainly will have a significant role to play long term in international financial transactions. We're almost at a point, I think, a bit like the dot-com boom, where we had a lot of investment back in the early 2000s, where people thought, oh, online the internet's the future for business, let's start investing in it. And it turned out that the internet at the time was not sufficiently sophisticated. This is before smartphones, before apps and everything. It simply wasn't sophisticated to match up some of the massive market valuations that were being made at the time, hence the sort of the dot-com boom and then crash that followed. And we could be looking at something similar here with cryptocurrency, where it simply has been heavily overvalued compared to the actual proportion of people actually using it and the type of transactions it can be used for. But there will come a point where I think more large organizations start saying, yes, we will start taking payments in cryptocurrency. And once that starts to happen, that will be the key in the door and will lead to its greater adoption and use overall. I think we'll also get greater regulatory controls, and the greater level of regulation will give people greater confidence and reassurance, which will in turn allow more vendors to say, yes, we will be comfortable in accepting payment via cryptocurrency, and that will happen. It just might take a lot of years or decades to get there, is the point. So therefore, I would still be very hesitant about making massive investments if you know, or investments of any type. If it's a bit like at the moment, I'm afraid, a roulette wheel. Don't put all your money on red or black if you can't afford to lose it ultimately.
Thanks, Peter. So that was our last news story for today. A big thank you to Anson Evaluate for helping to produce this webinar, and we will be back next week. Just a reminder that these episodes are available on our website, our YouTube channel, and podcast channels as well, such as Spotify, Amazon, and Apple Music. And we hope to see you again next week.